Welcome back, everyone. Our next event is a debate on whether there needs to be more global governance. Moderating this debate is Judge James C. Ho. Judge Ho is a circuit judge on the U.S. Court of Appeals for the Fifth Circuit. Before his appointment in 2018, he was co-chair of the National Appellate and Constitutional Law Practice Group of Gibson, Dunn & Crutcher, LLP. As an appellate litigator for over a decade, Judge Ho presented 50 oral arguments in federal and state courts nationwide. His decade as an appellate lawyer also included 3 years of service as a Solicitor General of Texas, the state's chief appellate and Supreme Court litigator. Judge Ho previously served in all 3 branches of the federal government. On the Senate Judiciary Committee, he served as chief counsel of the subcommittees on the Constitution and Immigration under Senator John Cornyn. At the Justice Department, he served as special assistant to the Assistant Attorney General for Civil Rights and an attorney advisor at the Office of Legal Counsel. He clerked for Judge Jerry E. Smith of the U.S. Court of Appeals for the Fifth Circuit and Justice Clarence Thomas of the U.S. Supreme Court. His record of public service also includes appointments as vice chair of the Federal Judicial Evaluation Committee in Texas, co-chair of the Judiciary Committee of the National Pacific Asian American Bar Association, member of the U.S. Magistrate Judge Merit Selection Panel for the Northern District of Texas, member of the U.S. Delegation to the United Nations Committee on the Elimination of Racial Discrimination, and member of the Continuity of Government Commission. He has also served as an adjunct professor of law at the University of Texas School of Law. Judge Ho graduated from Stanford University with honors and a BA in public policy, and the University of Chicago Law School with high honors. Judge Ho, thank you for joining us today.
Thank you, Eric. It's truly my honor to moderate today's Federal Society debate. I just regret that we're not gathering together in person. After all, so much of what happens in really any event, but especially at the Federal Society, so much of it happens not just during the scheduled panels, but also in the hallways. Remember catching up with old friends, making new ones, sharing and debating ideas about the law and the future of our great country. But at least we can do this this way and hopefully more in person in the future. Our debate today is slotted to last until 6:45 p.m. Eastern Time. I do suspect that we'll end much earlier. That's deliberate in order to give people time to refresh and perhaps get something to eat before the evening program begins at 7 o'clock. And finally, before we formally begin the debate, just a few brief comments about our format. I'm going to, after I introduce our speakers, I will ask them a few questions just to get the conversation going. I'll invite each of them to take some time to respond to the question and perhaps directly to each other. And that will be followed by some opportunity for Q&A involving the audience. Now, anyone who has a question in the audience is invited to type in your question by using the chat function on Zoom. Now, honestly, I have no idea what that means. Someone just told me to say that. I'm hoping that you young kids in the audience know what that means. Unfortunately, I understand that most people are viewing on YouTube or some other non-Zoom medium that does not permit that type of participation, but hopefully there are at least enough of you on Zoom that will have the opportunity for some good Q&A. And with that, I'll figure out how best to ask your questions on your behalf. And with that, I'll go ahead and get started by introducing our highly distinguished speakers who we are very fortunate to hear from today. First is Professor Oona A. Hathaway, Professor of International Law at Yale Law School, Professor of the Yale University Department of Political Science, and Director of the Yale Law School Center for Global Legal Challenges. In 2014 to 15, she took leave in order to serve as special counsel to the General Counsel at the U.S. Department of Defense, where she was awarded the Office of the Secretary of Defense Award for Excellence. She has published more than 40 law review articles and also authored The Internationalists: How a Radical Plan to Outlaw War Remade the World. Professor Jonathan Macy is the Sam Harris Professor of Corporate Law, Corporate Finance, and Securities Law at Yale University, and professor in the Yale School of Management. He is chair of the Yale University Advisory Committee on Investor Responsibility. Professor Macy previously has held professorships at Cornell, the University of Chicago, Harvard, and the University of Virginia. Professor Macy has published over 150 articles in leading legal and economics journals and 9 books, including Corporate Governance, Promises Kept, Promises Broken, as well as the treatise Macy on Corporation Law. Thanks to you both, professors, for participating today. And let me begin by observing that the earlier sessions of this wonderful conference have addressed an array of issues. And so I'd like to circle back here to several of them, but perhaps take a different perspective or a new perspective in light of our debate topic. And I'd like to ask whether more global governance is necessary or desirable in these various areas that we've been discussing in this conference. We won't be entirely retracing our steps, but we thought we'd revisit the debates as a way of tying together the conference at the end of the day and showing that there are a wide variety of global governance issues that we continue to discuss and debate and struggle with. Now, the first panel focused on the role of international law in U.S. constitutional interpretation. So let me take that in perhaps a slightly different direction and ask about the role of international courts. There have been debates, for example, over the role of the ICJ, the International Court of Justice, which found the United States in violation of international law in Avena and other Mexican nationals, a decision that the U.S. Supreme Court then refused to enforce. Moreover, it's my understanding that the United States government has put into place sanctions on judges and lawyers who were involved in the International Criminal Court's investigation of the United States for violations of international law in Afghanistan. So my question to the professors, and perhaps we'll begin with Professor Hathaway, what is the value or cost of the growing development of international courts and tribunals?
Thank you so much, Judge, for that question. And thank you so much for being here with us today. And thanks to the organizers of the conference for inviting me to speak to you. So this has certainly been one of the hot button issues in debates over international institutions and global governance more generally. And there are a lot of different ways in which this debate plays out. So let me take the 2 examples that you raised and talk about those. But if those who are watching want to talk about other courts, feel free to raise those in the Q&A. So one you mentioned is the Avena case, which is where the International Court of Justice ordered the United States to reconsider death sentences of 50 Mexican nationals whose Vienna Convention on Consular Rights had not been observed. What basically had happened is that when they were initially charged, their consulate should have been notified that they were being charged with a crime, and then the consulate should have had an opportunity to assist in the defense. That wasn't done, and so they didn't receive any assistance. And then after the death penalty was given, there was a realization across the board that for a long time, many U.S. courts had not been observing the obligation under the Vienna Convention on Consular Relations to notify the consuls when foreigners were being charged. And so this was then brought to the International Court of Justice. Now, the reason it got to go to the International Court of Justice was because the US had signed what's called an optional protocol, that is a sort of addition to the Vienna Convention on Consular Relations. And that optional protocol, this addition the US had signed and ratified, said that if there's a dispute under the convention, then it could go to the International Court of Justice. Now, why did the US sign that? It signed it probably because it was seen as advantageous to the United States. There was an expectation that if there was a dispute under the Vienna Convention, that the US might itself want to be able to take another party to court. And that if you certainly don't want to address the issue in the courts of the foreign state that's breaking the rules, you probably want to have someplace else to bring that, and the International Court of Justice is one possible venue. The other court that has attracted a lot of attention in recent years is the International Criminal Court, which you also mentioned. And this has recently been especially controversial because the prosecutor there has been permitted to proceed with an investigation of crimes that were committed in Afghanistan during the war there, not just by the United States, but by the Taliban and other actors as well. That investigation has been approved. There's sort of an initial approval process with the court that allows the prosecutor to begin to move forward. And that's when initially under the Trump administration, there were sanctions put in place against judges who are involved and against the prosecutor and others involved, including potentially lawyers who are just involved in representing clients at the International Criminal Court. Now, the first thing to keep in mind about both of these and really all international courts is that none of these courts have jurisdiction over Americans without reason. It's not like the courts themselves sort of all of a sudden decide that they want to have jurisdiction. They're granted jurisdiction through various rules, usually through treaties. So again, as I mentioned, the International Court of Justice had jurisdiction in the Vienna case because the US gave it to them by ratifying the optional protocol to the Vienna Convention. And again, it did so because Americans really benefit from the Vienna Convention. So if you go abroad, you travel abroad, and you get charged with a crime while you're abroad, you have the right under the Vienna Convention on Consular Relations, if the state that you're traveling in has signed and ratified that treaty, which most states have, you have the right to have the US consulate notified, and then they can assist in your defense. Now, that's a great thing. If you're an American traveling abroad, you want that because that means you're going to get American support and much less likelihood of sort of being railroaded and thrown in jail without anybody knowing it. And if there's a dispute, you want some place for that dispute to be able to go, and the ICJ is a pretty good place for that. So there's lots of reasons to think that why the US signed that was because it was seen as in the best interests of Americans. The same is true with the ICC. Now, the US has not joined the International Criminal Court, and that has been a key argument against this case. But what we need to recognize here is that Afghanistan has. So Afghanistan signed and ratified the Rome Statute, and these crimes are alleged to have occurred in Afghanistan. So if I go, for instance, to London and I commit a crime, I steal something, I can be brought in front of English courts because I committed my crime in England. And there's a similar principle at work here. So Afghanistan has given the right of jurisdiction to the International Criminal Court by signing the Rome Statute, and that's what gives the ICC jurisdiction over the matter here. So it's not like the courts are kind of grabbing the jurisdiction themselves. They've been granted the jurisdiction by states. So let me then turn to the question, should we have more of these courts? And there are a lot of courts, I will say. We've just talked about two of them. There's a huge number of courts. There's also lots of what are called arbitration panels. There's much more informal dispute resolution mechanisms at the international level. So there's lots of these. There are probably hundreds of different organizations for resolving disputes internationally. Why do all these things exist? Why do states create these? It's because they need some way to resolve disputes. These courts, these arbitral bodies, give you a way to resolve disputes. The alternative would be to have to go to a foreign court where you might not necessarily get a fair hearing. And so one of the reasons you might want to have an international court to resolve certain kinds of disputes is it provides a kind of fair ground on which to make your arguments. In addition to the ones we've just mentioned, for instance, there are arbitral bodies that address questions like investment dispute or commercial arbitration disputes. These are much less controversial, and they're very much favored by international business because this is an important way in which if your investment is being expropriated inappropriately by another state, you have recourse and you have a way to bring it to an arbitral body. And then under the New York Arbitration Convention, you can enforce that decision of that arbitral body pretty much everywhere in the world. And so states, businesses, individuals benefit from these courts, and that's why they have been created. And that's why I expect they'll continue to be created, and we'll see more of them. So, our courts are obviously great. That's the place of first recourse. So sometimes Americans are going to have disputes with foreigners, and we may prefer to have access to an international court or arbitral body rather than be stuck in the courts of other nations or have access to no court at all. So I think on the whole, there's good reason that we see these courts emerging, evolving, and continue to be expanded. Over to you, John.
Thank you so much, Oona. Very interesting. Before I want to make a kind of a 30-second preliminary statement with respect to international governance, world governance, and then try and address Judge Ho's very pertinent question about the International Court of Justice, and the ICC, the International Criminal Court. So there's a ton of global governance, and some global governance, and in particular, the major institutional features of global governance, I don't have any problem with. And by that, I mean the 4 treaties and 3 protocols that make up the Geneva Convention, ratified by 195 countries, the UN Law of the Sea, 165 countries, the Nuclear Non-Proliferation Treaty, Chemical Warfare Treaty, which has 190 signatories, Biological Warfare Treaty, 170 signatories. So I'm in favor of those. Now, the question is, do we need more? I get, particularly when we're talking about courts, what I want to say is there are a number of different ways or perspectives one could take in answering that question. And I guess since we're at the Federalist Society, I want to take 2. One is sort of a lawyer's perspective, and the other is maybe an economist's perspective. And I'll start with the economist's perspective because I think the answers are a lot clear. This is right. The economist would say the following about this question. The economist would say, this is a kind of an odd question because before we can tell if we have too much of something, we really need some kind of a model or theory to tell us kind of what's the right amount. Once we know the right amount is, we go out and count up how much we've got and see, are we above the line or below the line? And the only thing I want to say about the economist approach is the problem that we have, generally speaking, is what economists call the tendency to succumb to the what's known as the nirvana fallacy. I don't know how many people are familiar with this famous economic fallacy. The nirvana fallacy originated with Harold Demsetz from UCLA and of course Ronald Coase from Chicago. That basically it says that when one should not view the relevant choice as between an ideal norm and an existing imperfect institutional arrangement. In other words, the nirvana fallacy is simply the logical error of comparing actual things with unrealistic idealized alternatives. So, you know, the question I have with respect to the, you know, that my concern, I guess, from in a way an economist's point of view is, you know, what, let me see how to put this. You know, what are the kind of actual outcomes that we're going to observe? And now this dovetails into the legal, because that's just kind of the question that a lawyer would ask, right? The lawyer would say, well, you know, I'm gonna try to represent my client. I'm gonna try to, if I can, and it's legal and ethical, engage in forum shopping, and I want a forum where my case will be heard with some sympathy, or I'll get kind of a fair shake. Now, Professor Hathaway said, and this is an empirical claim, and I'm not disputing it. Well, I guess I kind of am a little bit disputing it, but I don't have any data, so I'm not going to dispute it too hard. But that is, she made, with respect to her laudatory words about the Vienna Convention, and I share her support for the Vienna Convention, incidentally, along with the other treaties that I mentioned. But she said one of the nice things is, you know, people get a fair shake there. Well, I am not convinced of that. Clearly, you know, we had as recently as February 5th, we had the Biden State Department reject the determination, for example, for the ICC to claim jurisdiction in the West Bank, East Jerusalem, and Gaza over Israelis. There's a very strong, at least when you're talking about U.S. soldiers or Israeli citizens, there is some reason to believe, in my view, that we may not be in quite the sort of John Lennon, Yoko Ono, give peace a chance mode that some might think that we are. The other thing that gives me pause for, is one looks at you sort of Google the list or try to compile a list of the most repressive regimes, the Sudans or Syrias or Russia's up there, other Iran, and it is a little weird to my way of thinking. We see a pretty big hands, as Judge Ho's remarks, I think, illustrated. We see an unusual amount of prosecutorial attention on democracies and precious little prosecutorial attention on repressive, human rights trampling dictatorships. Now, I'm sure there are plenty of reasons for this. There's not enough international component, or et cetera, but I'm kind of reject that. So my view is we that the basic approach I take is the basic question I ask is, if someone asks me if I like something, the visceral response of the economist is always, well, I don't know if I like it. Do I like it as compared with what? Do I like it as opposed to getting hit over the head with a stick? Or do I like it as opposed to having the lions lay down with the lamb and having a constitutional right scrupulously observed? Well, I feel the same way about the courts that Judge Ho pointed us to. I'm skeptical about their even-handedness. It really depends on, as so often the case with courts whose legitimacy is rightfully subject to some doubt, as how much they like the defendants. So that's where I am. Thank you for that question, Judge.
Well, thank you both. Let me turn to the topic of our second panel, which was trade and sovereignty. What is the value of a global trade institution such as the World Trade Organization? And should we be switching to more use of bilateral arrangements, or is there a role for global organizations in this space? What course, in other words, what course would you all ultimately recommend going forward? Do you want more global governance as necessary in the area of trade, or less? Professor Macy, you want to start and take this one?
Yep. So this is with respect to international trade. I am in favor of free trade. Unambiguously, I'm from the libertarian wing of the Federalist Society, and I believe that free trade benefits the buyer as well as the seller. It leads to, I believe, in the McDonald's paradigm, the fact that there's never been a war between two countries, both of which had a operational McDonald's hamburger franchise. I believe in commerce. I believe in free trade. With respect to your specific question, Judge, about bilateral treaties versus global treaties, I'm in favor of global treaties above bilateral treaties. And the reason for that is simply, again, I'm taking an economics point of view in a lot of these things, but there's an externality problem. Whenever you have two parties, particularly powerful economic parties, engaging in trade agreements, there is always a concern that there'll be third parties, that is non-signatory countries, in a bilateral trade agreement, are getting the proverbial short end of the stick, and you get some agreement that may make country A and C better off, but maybe not country B. So I'm in favor of global treaties. Having said that, we live in the real world. The tremendous, when it comes to foreign trade, there are very few areas of academic inquiry where the public choice or interest group model is not more robust. Our free trade is not based on some idealized, basic kind of notion of, give peace a chance and let's come together in economic brotherhood and sisterhood. We have, the powerful sugar lobby or steel manufacturers or auto there are a very long list. And so the battle for free trade is, I think, in a way, sort of never ending. Obviously, at least in my humble opinion, the Trump administration was an unremitting nightmare from a free trade point of view. And even though I don't agree with, Joe Biden about everything, I think his views are closer to mine when it comes to trade. So those are my opinions, and I'm sticking to them, Judge. Thanks for the question.
So I can respond. And on this question, I think that we are in pretty close alignment. But let me say just a little bit more. So for those viewers who may not know, the World Trade Organization that you mentioned is the successor organization to the trade regime that the United States and its allies really worked hard to build in the years immediately following World War II. And the idea was that we need a robust global economic order if we're going to keep the peace, that we need a way to rebuild after World War II, that we need a way to expand global trade relations. This is the McDonald thesis that John referred to, this idea that if we have robust, thick trade relations, that we're going to be less likely to go to war. But of course, also, economies have been devastated after the war, and there was an effort to try and rebuild them. And there was a belief that free trade was key to that. Now there's 164 members of the World Trade Organization, and being a member comes with a bunch of obligations, so as well as benefits. So obligations are, there's a bunch of rules that you have to follow if you're a member of the World Trade Organization. There's a set of tariffs, for instance, that everybody has to follow, that you have to, you can put a certain limited level of tariffs on certain goods. Other countries also can only put that same level of tariffs on your goods. So you may be limited in terms of the amount of tariffs you put on footwear that you're importing, but similarly, they're also limited in terms of the amount of tariffs that they can put on footwear and other goods that you might want to export. So it requires everybody follow the same basic set of sort of baseline rules when they trade. And then there's a dispute resolution process connected to it. So if you break the rules, then a party can complain, bring it to the dispute resolution body. That body then will resolve, is there a dispute or not? It's another international court. And then if they find against you, there's an appeals process. But eventually what they can do is allow you to put in place countermeasures. The party that's harmed can put in place countermeasures. So this is a way of giving bite to the obligations. And the idea behind it was that not only was it going to set this sort of baseline set of rules for nations and encourage free trade and set lower trade barriers across all countries that were part of the World Trade Organization, but also the idea of this dispute resolution process was that there would try to prevent a kind of rolling trade war, that you didn't want to have a kind of breakdown in trade relations where states started doing tit for tat tariffs against one another and trade sanctions against one another that would get out of control. The kind of fiasco that, for instance, preceded the Great Depression, that may have been precipitated in part by the US Smoot-Hawley tariffs. So the idea was, let's have a mechanism in place to put kind of the brakes on that kind of unraveling of the free trade system. And the longstanding consensus has been that this is in the best interest of everyone. And yet we've seen that consensus to some degree unravel in the last several years. And I think that there's a few reasons for that. The legitimate reason, though on the whole, I think some of the attacks on free trade are not based in fact, but I do think that some of the concerns arise from the fact that we didn't fully appreciate the fact that free trade is on the whole in the interest of the United States as a whole, but the certain communities are going to be particularly hard hit. Those communities that are supported by industries where the US just simply can't, in industries the US can't compete in on the global market. So lately, one area in which we've seen this be bandied about is steel. And that has actually been a kind of an area of debate for quite some time, actually. US has at various points kind of put in place what are regarded as illegal steel tariffs to try and preserve steel manufacturing in the United States. When really there are other countries who can produce steel much more effectively at lower costs than we can. And so when we compete on a fair and level playing ground, they just beat us. That's just the reality of the matter. Now that those hard hit communities haven't been sufficiently supported. And so you've got people who are thrown out of work by full free trade, that it's not just individuals who are put off work, but it's whole communities that suffer. And I think we didn't do enough to really address those costs. We had a sort of very minimal trade adjustment assistance, but nowhere near enough. Also not sufficient retraining of people so that they could move into other industries where they could earn a sort of roughly equivalent incomes. And so, you know, I think that short-sightedness created real pain for not only individuals, but communities that were hurt by free trade. And I think we could have and should have done more to try and address that. I don't think the right answer, like John, I don't think the right answer is stop free trade. I think that's the mistaken approach that we sometimes hear. I think the right answer is continue free trade, but be mindful that the costs are real and try to address them through much more robust trade adjustment assistance, better education, thinking about what industries can come in to replace that through much more robust unemployment insurance. So other ways to address the real harms that people do suffer as a result of the adjustments that are brought about through free trade. So like John, I'm a believer in free trade. And I think there's some role for bilateral arrangements, but I don't think they should be a substitute for global free trade. Really, these matters are best dealt with on a global stage and much more effectively dealt with on a global stage. Rather than individually negotiating with 164 countries, much better to do it, if we can, through broader multilateral arrangements.
Okay. So shifting gears from trade to war, or to use Professor Macy's framework, from McDonald's to no McDonald's. The third panel examined presidential war powers and the capacity of the President of the United States to use force without authorization from Congress, and the obviously debate over that. What is the role for global governance when it comes to war and military use? Now, the United Nations Charter prohibits nations from using force against one another except in self-defense or where authorized by the UN Security Council. But there have obviously been times when states, including the United States, have ignored those rules or at least pressed the boundaries. Should there be robust global institutions to control the use of force? And is the current system in this regard adequate? Professor Hathaway, what do you have to say on this?
Yeah, thank you for that question. You know, I really think that this set of rules is foundational to the modern legal order. Let's start with the UN Charter. So the UN Charter was put in place after World War II. And the fundamental commitment in the Charter is in Article 2.4, and that is a prohibition on use of force. All members of the United Nations are obligated to refrain from the use of force against every other state in the world, under Article 2.4. Now, I spend a lot of time providing the background on that in my book with Scott Shapiro, The Internationalist. So if anybody's interested, you should take a look at that. In the book, we argue that the idea began in 1928 with the Kellogg-Briand Pact, and then the UN Charter's really reaffirmation of that central obligation. And the Charter basically says, look, you can't go to war against one another. And in the book, we try to show that while that may seem not particularly interesting or important of a commitment, it is if you view it against history. So historically, states were allowed to go to war to resolve their disputes. So a state fails to repay its debts, you can go to war against it. The king steals another king's wife, you can go to war over it. You interfere with one another's trade relations, you can go to war over it. That was historically how disputes were settled between states if they couldn't amicably resolve them. And what the UN Charter does is it says you can't do that anymore. You can't go to war against each other if you have disputes. The very limited reasons that you can go to war. You can act in your own self-defense under Article 51, circumscribed right of self-defense. The UN Security Council, which is a small number of states, US is one of the permanent 5 members of the Security Council. They can authorize an intervention. US is one of the members of the so-called P5, the 5 permanent members, can veto any of those interventions. So it's a uniquely strong position in being able to authorize or not authorize war. And then there's a sort of shadow or sort of understood to be that states can consent to the use of force on their territory. So for instance, US right now is using force in Iraq with the consent of the Iraqi government to assist in anti-terrorist operations. So this prohibition on use of force has not been perfectly observed. Obviously, one just needs to open a newspaper or I guess more likely open Twitter or look at Google or YouTube or whatever to know that, that this is not perfectly observed, obviously. But the level of conflict measurably has gone down substantially in the post-World War II era. There have been very few wars between states, what political scientists would call interstate wars. To the extent that there have been conflicts, they're more likely to have been civil wars or what we call intrastate wars, but wars between states, which is what's prohibited by Article 2.4, have substantially reduced. The numbers have fallen off a cliff compared to where they were before World War II, and that's at least partially due to this institutional structure that we have in the UN Charter, the prohibition in Article 2.4, and then a provision that allows the Security Council to authorize uses of force. For instance, when that's broken, when Iraq invaded Kuwait, the US and allies banded together as authorized under the UN Charter to expel it from Kuwait for violating Article 2.4. Now, this hasn't been perfectly observed, as I said, and then lately we've seen lots of ways in which it's being chipped away at. And honestly, this is quite concerning. I think we ought to all be worried about that. So just to give a few quick examples, Russia invaded and seized Crimea from Ukraine in 2014. That's the first successful conquest in Europe since World War II. We really should be deeply concerned about that and what it signals for Russia's intent in the region. China has occupied contested territory in the South China Sea, turning a number of islands and rocks into military installations. These are contested territories. It rejected an arbitral panel that told it shouldn't be doing this, and it just kept doing it anyhow. And the US itself has been responsible for stretching the idea of self-defense really to its breaking point by claiming a wide range of operations in the Middle East are justified as acts of self-defense. For instance, the killing of Qasem Soleimani in Iraq in early 2000 was justified as an act of self-defense, but the administration really never provided any evidence that there was an immediate threat that under Article 51 would have justified an act of self-defense. So there's been a kind of chipping away at this norm. And those of us who think that this is a kind of foundational norm of the international order are concerned by that. And I think we should be concerned by that. What do I hope we can do about it? I think honestly, it really is up to the US to lead the way here. As a leading member of the Security Council, it's in a unique position to be able to do so. It has played an important role in the past. For instance, it led the charge on putting in place economic sanctions against Russia after the Crimea invasion. It has led the world in the pushback against China in the South China Sea by refusing to acknowledge and accept the claims that it has made over certain territories in the South China Sea. I would like to see it be more careful about the US be more careful about its own behavior. I really do think pushing the boundaries of self-defense to the point where the exception swallows the rule is very troubling. And unfortunately, the Biden administration seems to be following in the footsteps of previous administrations. Recently took a strike against Iranian-supported non-state actor groups in Syria, claiming that it was for self-defense because they posed a threat in Iraq. But we haven't seen a whole lot of evidence that, in fact, that was justified. So I would like to see the U.S. do more to sort of reinforce that norm and not to continue the chipping away at it.
Thanks, Oona. So this discussion reminds me of the last couple of sentences in Grant Gilmore's famous book, The Death of Contract, with respect to international treaties about war. And Grant Gilmore said, in heaven, there will be no law, and the lion will lie down with the lamb. In hell, there will be nothing but law, and due process will be meticulously observed. And I think that I am skeptical a little bit about international treaties with respect to war for a few reasons, some of which tie into some of what Professor Hathaway was saying, others don't. Particularly of importance, and Professor Hathaway touched on this, and I thought in a very effective way, is war is okay, as I understand it, if the actions taken are in self-defense. And I am not particularly supportive of the kind of standard issue public international law definition of self-defense. I don't think that it is effective in an era of terrorism, in an era of technology, in an era where people can inflict tremendous damage on others. So the essential working notion of self-defense is, well, there's self-defense if there's an immediate threat. So this is kind of crazy in my view. It's from an era, kind of World War I, where you see, or, you think about the 67 Israeli war, you see, masses of troops teaming on your border. And then you can kind of maybe, if you think when they're going to attack, or you believe it's an immediate threat of attack, you can, take kind of preemptive action. But what about people who are, flying planes into buildings, era of human and technological intelligence? I think that, as we've seen with respect to recent U.S. actions in the Middle East and Israeli actions for that matter, I think, my view is that the notion of what is an immediate threat and therefore what is self-defense has got to be an expansive concept. And this leads me to my final and kind of most important point, that is Professor Hathaway rightly identified one of the reasons why we want to have treaties with respect to armed conflict. And obviously, and certainly she's right, one reason is we want to reduce conflict. I'm not sure, number one, that these treaties are actually reducing conflict. One could say that what's really reducing conflict is The stakes have become so much higher, particularly in an era of people have extremely powerful offensive and defensive weaponry. So it's hard to know. Conflict has been on the subsidence. Professor Hathaway is absolutely right about that. I think reasonable people can kind of disagree about the kind of root cause for the diminution in conflict. The second thing is, I don't think the reduction in conflict is actually, it's not the only, and it may not even be the most important reason why we want to avoid armed conflict. Sure, we want less of it, but the other thing we want is to have, is to protect the most vulnerable countries, right? So the right of self-defense doesn't necessarily help us very much there. Suppose, I'm not suggesting that this should have been done by any stretch, but hypothetically, if some country like Russia were to invade illegally some other country like Crimea, and some other countries like this NATO or some other group of countries like NATO were to come to the rescue, this would not be considered self-defense. We can't have that. So I don't know that the current treaty structure does a very good job in protecting the most vulnerable countries. The last thing I'll say about this is a kind of a prisoner's dilemma point, that, to the extent that this self-defense notion means that you can't take action until you're an imminent threat, is a tremendous disadvantage for the most vulnerable, for weaker countries, where their only possible path to victory, if you will, or path to self-preservation may be a preemptive strike. So, those are my views. I'm not really terribly far apart, I don't think, from Professor Hathaway's point of view about this, other than I have a kind of I'm just cautious, and I take a very expansive view, if you will, particularly when I'm talking about a vulnerable country that is in imminent danger from a despotic, authoritarian regime. I take a pretty broad view of what constitutes self-defense. That I may be mistaken, but I have a feeling, I got the sense from what Professor Hathaway said, that my view of how that term should be described from self-defense is, mine may be a little bit more broad than hers is. But thank you, Judge.
Judge, may I jump in just with a super quick response?
Oh, please do.
So I think I agree with a lot of what John said, but just a couple of things I would disagree with. So one point to remember is that Article 51 allows individual self-defense. So U.S. can defend itself from a threat. It also does permit collective self-defense. So if a country is attacked and it asks for help, then a state can come to its assistance. The only limitation there is that the state asking for help has to actually have an Article 51 right of its own self-defense. So just to take the Kuwait example that I mentioned before, when Iraq invaded Kuwait, Kuwait did seek assistance from the global community, and the global community responded. There were Security Council resolutions there, but it also could have been justified, arguably just under a collective self-defense justification under Article 51. And a lot of U.S. operations in the Middle East are justified not just under U.S. self-defense, but collective self-defense as well. I think that the challenge and the tension, and I think that the point you made, John, it gets to the crux of the matter, which is the sense that states want to be able to defend themselves. And that leads to this sort of expansive, this kind of continual expansion of the idea of self-defense, particularly in a world of non-state actors, which these rules were not really created after World War II with non-state actors in mind. That really is it's not an entirely new phenomenon, but it has been really a growing phenomenon, the idea of states defending themselves, going to war to defend themselves against non-state actors. But the difficulty, I guess I want to point to, is that the more flexible those rules are and the more expansive they are, the more the idea of defense slides into offense. And so one state's defensive war is another state's offensive war. And that, I think, opens the door to a lot of conflicts that we might want to prevent. Just to take an example, one of the claims that Russia makes for its continuing military operations in eastern Ukraine, where it's continued to foment disruption and supports separatist groups, is that it is defending Russian nationals in Ukraine. And so once we open the door to this sort of expansive idea of self-defense, and we use it in one context, it opens the door to those, on the other side to also use it as well. And then once defense becomes so expansive, the prohibition on offense really becomes kind of irrelevant. And so I think this is just the challenge we face right now in how do we maintain a prohibition on use of force that's effective in a world where self-defense has been expanded greatly in ways that then threaten to become the exception that undermines the rule.
Thank you. I agree with a lot of that. I think I don't think that the term self-defense is infinitely elastic, and I think there have to be some limits. I just think imminent danger is a little too far, and certainly Professor Hathaway is right that at least in theory it would be possible to have an infinitely elastic definition. I'm not in favor of that. With respect to Kuwait and Iraq, I certainly think, a lot of countries, including, of course, the US, went to battle to make sure that Kuwaitis human rights were being violated by their own monarchs rather than Saddam Hussein and his monarchy. I don't know quite what to make of that, other than it is an example of the country availing itself of its right to petition for collective self-defense. I don't think it was a moment of other regarding international diplomacy that motivated countries to take up arms on behalf of Kuwaitis. And I think I'm also in agreement with Professor Hathaway that the continuing blatant violation of international law by Russia in Ukraine is an embarrassment on the notion that we have treaties with respect to limiting countries' ability to go to war. So thank you.
The fourth panel and our final one for the convention examined the topic of international human rights law. And that panel discussed that, at least when it comes to democratic nations, some would argue that international human rights agreements may be of lower, less robust quality than the nation's own norms, and thereby detract from national sovereignty, while others might worry that international human rights agreements are largely unenforceable and otherwise ineffective. So given all that, should there be more robust governance when it comes to international human rights? And if not, why not? Professor Macy, what do you think?
Yeah, it's very difficult to be opposed to human rights, of course, and I'm not in any way, shape, or form opposed to human rights. I do think, though, that and similarly, I'm not particularly sympathetic to the idea that there's going to be a sort of reversion to the mean, or if we have an international accord, nobody, I don't think, I mean, I missed that panel. I could be wrong about this, but I'd be stunned if anybody was seriously arguing that, Sweden or Norway couldn't have higher human rights standards than than the minimum kind of mandatory minimum, if you will, established by an international treaty. So I'm not particularly concerned about that. It just gets back to sort of the Russia-Ukraine point, which is, we have a situation in which people who care about human rights are scrupulously trying to comply with their responsibilities under international law. I'm not aggressive in defining international law, but I recognize there is such a thing as international law, and to the extent that it means anything, which I think it does, it means that countries are violating international law and people are violating international law when they engage in genocide or egregious human rights violations. My problem is that there's both too much of it and not enough. That is, there's not enough human rights in the sense that, we see South Sudan and we see so many countries where human rights are routinely violated without very much happening. And we see not enough of it in the sense that certain countries that are unpopular and kind of pariah nations on the international stage are unfairly singled out for human rights violations. So we're kind of destroying the legitimacy of the international human rights framework by the lack of credible enforcement and by the non-random, the kind of unpopular world actor, whether it's Israel or the United States or whoever, is, I think, unfairly singled out for kind of attention in these international human rights contexts. So I definitely am in favor of, having a robust, effective human rights governance system. I'm very much looking forward to hearing my colleague, Professor Hathaway. And the question is, does that exist? I'm not asking, is it possible, but is that something that we have now? There is a lot of international human rights law. I don't think we're lacking for quantity. I think we're lacking for quality. Thank you.
Yeah, well, so this, that my first law review article was called "Do Human Rights Treaties Make a Difference?" And it concluded that
great article, by the way.
Thank you. And it concluded that states that ratify human rights treaties not only don't generally do better than those that don't, but that they somewhat counterintuitively sometimes do worse. And that was something of a bombshell in the human rights community, because, of course, a lot of effort had been put into creating these treaties and encouraging states to ratify them. And part of the reason for that result is that human rights treaties, with only a few exceptions, generally are not internationally enforced, as you just said. So it's very easy for a state that has a bad human rights record and doesn't really intend to change it to ratify a treaty and then not do anything any differently as a result of having ratified that treaty. And so the question then is, does that mean that this whole thing is pointless? Is the idea of having all of these international treaties that generally don't have an international enforcement mechanism, I want to enforce international enforcement mechanism, does it mean that that's pointless? I don't think so, but I definitely agree with you, John, that it does mean we have to think carefully. Like, the next step in the human rights revolution is thinking about, how do we make those promises a reality? How do we give them real life? How do we make them actually effective? We need better ways to enforce these human rights obligations if we think they're actually important commitments. And I do think they're important commitments. I think countries should not torture citizens. I think that people should have the freedom of assembly, the freedom of speech. These basic protections that are included in human rights treaties are pretty fundamental. And in fact, many of these human rights obligations are ones the US really pressed hard for in the years after World War II. And in many ways, many of them are commitments that the US had made domestically and wanted to internationalize. The International Convention on Civil and Political Rights really is an internationalization of the Bill of Rights. So we need better ways to enforce these obligations. I think you're absolutely right in the critique that the problem is that we have these promises, but we too often don't live up to them. And the question is, how do we do that? People are not particularly eager to create international courts for that purpose. It's going back to our first conversation. There are some international courts that work for this purpose. So for instance, in Europe, there's the European Convention on Human Rights, which is enforced by a European court on human rights. And that court has actually been quite effective in many ways in finding human rights violators in being clear that they've made violations and requiring them to make changes. Russia, for instance, gets brought in front of that court an awful lot and has been ordered to pay a lot of money and to make various changes. It's made some of them, not as many as one might hope. So that's one hopeful example. The Inter-American Court is also one that is generally viewed as somewhat effective. It doesn't have compulsory jurisdiction like the European Court of Human Rights. And so that makes it easy for states to kind of wiggle their way out of it. But it is nonetheless a mechanism, an international mechanism for enforcing human rights. But frankly, the way in which most human rights are going to be enforced is going to be domestically. And so just to take an example, we haven't talked about the Alien Tort Statute, so I might as well get to that. The Alien Tort Statute is one way in which that is enforced in the United States. It's been a controversial tool for enforcing human rights, to be frank. This is that statute, for those who don't remember, that was enacted by the first Congress, and it allows an alien, that is a non-American, to sue in tort for violations of the law of nations. And there's been lots of debate about what exactly that means. There's a case in front of the Supreme Court right now, Nestle v. Doe, which is joined with Cargill v. Doe. And in that case, the claim is that Nestle and Cargill were buying from cocoa suppliers or working closely with cocoa suppliers in the Ivory Coast that were using child slave labor that was of children trafficked from Mali to the Cote d'Ivoire to work in these cocoa plantations. And so the claim is that they aided and abetted child slavery, and they're being sued. The former child slaves are suing them in U.S. court. And the question in front of the Supreme Court right now is, are we going to let that case proceed? Can corporations be held liable for aiding and abetting a human rights violation, here child slavery, by these cocoa plantations that they don't directly run, but that they work closely with and that they buy cocoa from? And we'll see how that case turns out, but that has been one domestic mechanism for enforcing human rights in US courts. It has been a pretty important one. It's also been a somewhat controversial one because corporations, for obvious reasons, don't much like it because it's used to enforce human rights obligations against them for actions often taken by governments or suppliers that they work closely with, but that generally the corporations themselves are not engaging in the human rights violations. There's movements, not just in the United States, to enforce human rights in this way, but in Europe as well. There have been more cases recently that are similarly against corporations that engage in violations, human rights violations and environmental violations, either directly or through subsidiaries in other countries, particularly in the third world. There's cases in both the UK courts and Dutch courts against Shell, Dutch oil company, for environmental degradation, oil spills basically in Nigeria. And both just recently in the last couple of months, both UK and Dutch courts have allowed those cases to proceed. If that continues and that sets a trend, like that is one way in which human rights could be enforced. Like people may not love that way, but that is one way in which it could be done. It can also be enforced through local courts. The problem is that generally speaking, in the places where the human rights violations are happening, those courts are not particularly friendly to cases being brought by the victims of these human rights violations. Usually the government has some complicity or role in the violations. and is not eager to allow these cases to proceed. So generally they proceed outside of the country where the violations are happening, precisely because there isn't availability of a court locally. And in Europe, there's a move to move towards requirement of due diligence regarding supply chains. So due diligence of to ensure that there aren't human rights violations taking place in the supply chain. There's a new rule that's likely to be issued in the near term, requiring that corporations that do a significant amount of business in Europe understand and know and check and make sure that their supply chains are not complicit in significant human rights abuses. So those are ways in which you could make human rights effective. Not everybody likes that. Obviously companies are not always super happy about being held responsible for this, although I think what they also do like is clarity. I think what they don't like is lack of clarity about what they do and do not have to do. But the next step I think we do have to think about is, if we have these great human rights obligations, prohibition on torture, prohibition on violations of civil and political rights, there's a whole host of these obligations, prohibition on genocide. How are we going to make them a reality? And what can people live with? And how do we think it's fair and reasonable to pursue these rights going forward? And that, I think, is kind of the next step that the human rights movement has to make.
Professor Macy, if you were saying something, I don't think we heard you.
Sorry, I had a couple of quick points I wanted to make in connection with what Oona Hathaway just said. I don't think this is terribly inconsistent at all with anything she was saying. One thing I'd like to point out is that the statute that she was talking about, the Alien Tort Claims Statute, was actually promulgated in 1789. Went a long way before enforcement started. It was a Paraguayan case in the early 90s, but it's a venerable statute, so it's not like some new wave thing that the current generation of scholars. Speaking of the current generation of scholars, Oona, I was very impressed. You're young enough to remember your first law review article. I think mine was like a commentary on the Magna Carta or something. But anyway, that was good. I was trying to remember mine. Second is, in addition to that, we have the Torture Victims Protection Act in the U.S., which allows private lawsuits. The other thing I wanted to say, and I think I'm right about this, just as a factual matter, but Oona, you can correct me if I'm mistaken. You're quite right to say that in the U.S. We do have these alien tort statute that permits lawsuits under certain circumstances. I believe that in addition to that, there's a growing number of international human rights cases being brought in German domestic courts where we're seeing that. And of course, maybe the apogee of this, what might have been, of course, the Israeli kidnapping of Adolf Eichmann and transporting him to stand trial. I don't know what, I just watched maybe my 12th movie about that the other day on Netflix. I'm not quite sure what I think of that from an international law point of view, but it definitely is, one example of an effort to have enforcement of human rights. So thank you.
Wonderful. Well, we're going to start with some questions from the audience, and I'm going to give Eric the chance to ask the first one.
Thank you, Judge. Somewhat greedily taking my status as a panelist technically on this video to ask the first question here. So my question deals a little bit more with the second topic that was covered by the debaters today. Particularly that of the WTO and generally of international economic organizations and governance structures. So I think GATT and the pre-WTO structure was referenced in that conversation. And my question is basically, at the time when GATT was created and for much of its history, the United States and liberal democracies in Europe constituted the vast majority of that structure. And America's largest rivals and most economically and politically powerful ones were not part of that structure. And yet now we're living in a time where our we do have more rivals than at that point, and those rivals have very extensive resources, and those rivals are now within the same governance structures that we are in. And so I'm wondering what the debaters think about how we should approach that in terms of being part of those global governance structures and how we should behave within those global governance structures. Thank you.
I'm happy to start. This is actually an area in which I have focused my own scholarship a little bit, and the right way I think to approach this question is not the way that it is usually approached. But if we take a standard sort of political science approach to bureaucracy, we have people like Anthony Downs and William Niskanen and Gordon Tullox, a lot of people who say, what do bureaucracies do? They maximize their own power and prestige and budget and things like that. And what's really interesting about trying to apply this sort of public choice model of bureaucracy to international organizations, whether it's the World Trade Organization or the European Central Bank or a lot of these other, or the Bank of International Settlements, which promulgates the International Capital Accords, is a question we should ask ourselves is, if this theory of bureaucracy, it's kind of interested me for decades, if people are really interested in, or subscribe to, as I tend to, some version of these theories of bureaucracy, why do we ever observe an international agreement, right? If I'm in the Commerce Department in Washington, and I accede to or agree to an international agreement, or I'm at the Fed and I agree to international capital accords, I've just outsourced my power and authority to some foreign tribunal. This is not a normative complaint. I'm not saying doing that is bad. I'm just saying it's surprising from a kind of, what we do is we see people voluntarily giving up local domestic authority. Now, this is not the case with, enforcing international human rights where you're extending your power. But something like the Capital Accords, you really do observe legislation and regulation that is in some interesting way in tension with the theory of bureaucracy and saying, wow, what are we doing here? And so, but I don't want to go on too long other than to say that my explanation for this, my reconciliation of what we're observing with this theory of bureaucracy is simple. It's technology and globalization. It is not possible for a European country to manage their own monetary policy. They have to band together in the European Central Bank in order to be effective, because the economy is global and capital flows just move too easily, and foreign exchange trading is more powerful than central banks, unless they're very big central banks like US, China, Europe. Similarly, with respect to capital accords, countries cannot set capital accords because equity is just so expensive for banks that anybody that tries to unilaterally set a significant capital requirement for their domestic financial institutions is only going to end up putting their domestic financial institutions at a huge competitive disadvantage with respect to their cost of capital. So we get international accords. So my view is, we're going to see an increasing trend, an increasing power. What do we observe people do? They act in, I think, to a large extent in their own country's self-interest, but that's my view of these international organizations from a kind of bureaucratic perspective.
I'll say a few words as well. So I take the spirit of your question as at least in part this idea that, well, look, now that all our competitors are in these organizations, is it really in our best interests? Like there's a little bit of that kind of, does this really help us all that much? Because it doesn't help us get ahead of them if they also get advantage of all the same kinds of rules and regulations that we get to take advantage of. And I think to that, I would say a couple of things. One is, there used to be this theory of political science that sort of endorsed that view. So there was a view of political science that basically you couldn't have a robust and successful free trade regime between states because inevitably, although all states will benefit from a free trade regime, inevitably some or one will benefit more than others. And so they will grow faster than their competitors. And in doing so, will change the balance of power between the parties in ways that are going to be disadvantageous to whoever is sort of, although rising, not rising as fast as their competitor, and therefore free trade arrangements are ultimately going to break down because whoever is not benefiting as much is going to want to pull out of it. And I think what we see is that the modern era has kind of disproved that theory. I do think the fact that these things are intertwined. I think the fact that we have Article 2.4, which prohibits states from using force against one another, does help because you're not constantly afraid that if another state has more power than you, they're going to use it to go to war against you. And for lots of human history, that was a real concern. I also think that it just in this era, the reality is that if you're not in it and benefiting from it, then other states are going to be in it and benefiting from it. So pulling out of it is not going to do you any good. And moreover, being a part of these global institutions with your competitors. So for instance, take China. Being in the WTO with China is advantageous ultimately to the United States because say China breaks the rules, which it does. That there is a mechanism under the WTO for the U.S. to bring a case against against China, and it has done that several times. There's lots of cases the U.S. has brought against China for violations, and it's allowed to put in place countermeasures in response to those violations. And it's a way of policing the system so your competitor doesn't take an unfair advantage of the rules. So I think ultimately in this world, you kind of have to be a part of these global institutions because otherwise the party's going to go on without you, and you're ultimately going to lose out. And being a part of these global institutions generally is better for you than worse because it gives you tools to enforce the rules against everybody else. Whereas if you're out of the system, you don't have those tools, and so you can't police the system as effectively. So ultimately, I think we're better off for having those institutions, even when our competitors are part of them.
Well, we're getting close to the end of our time here, but I did want to at least get one question from our Zoom chat feature. And so the question is, pushing for human rights internationally is difficult when it comes to bad actors like China and Burma. How can the U.S. pursue international human rights from a position of strength?
I don't mind taking this one first. And John, you should jump in if you have other thoughts. Yeah, it's a really difficult challenge, I think, that we face. And the recent sort of, shall we say, not breakdown in talks, but sort of energetic exchange of views between US representatives and Chinese representatives in Alaska illustrates the challenge that the administration faces right now. The Chinese representatives are clearly apprehensive about the fact that the Biden administration is making human rights a bigger part of its foreign policy agenda, and sort of uncertain and not particularly happy about that. And nonetheless, the Biden administration pursuing that is a key goal of U.S. Foreign policy, because ultimately we have certain values that we stand for in the world, and they're important to us. And those are values that we want to articulate and that we want to stand up for. How can we do it from a position of strength? I mean, I think that it's a multi-layered problem. It's not something where you can do it sort of it's not a one-shot deal. And I think China and Burma, the two countries that you mentioned, are quite different from one another, although obviously they're intertwined because China is a major sponsor of Burma. With Burma, I think you have more opportunities for push-pull. You have opportunities for conditioning investment on certain kinds of human rights policies, and for withholding investment in cases where you're not confident that human rights obligations are going to be properly observed, and creating very clear conditions for allowing U.S. investment and pulling out investment when human rights violations take place, which is what has happened in recent months and years in Burma. There's been this sort of push-pull, this kind of back and forth around the US investment, triggered in part by the genocidal behavior of the regime against the Rohingya Muslims. China is a little bit harder because obviously they own a huge part of our debt. We have major trade relations with them. And we're significant competitors of theirs. And so it's not quite as simple. Historically, we did condition trade relations on certain kinds of human rights obligations with China. And there was a much more explicit conditioning of continued trade relations on human rights. When China joined the WTO, that was relaxed, and that was one cost of the decision to admit China into the WTO. And so it becomes much more of a matter of sort of ongoing diplomatic interaction, pressing China, encouraging it, cajoling it, conditioning certain kinds of relationships and agreements and arrangements, and frankly calling out China, calling what's happening to the Uyghurs genocide is a really powerful thing. It's very embarrassing to the Chinese government. That's part of the reason for their angry response to American representatives. But I do think that those kinds of steps are important and are part of an ongoing conversation. I think too, we have to be aware that China's always had a kind of resistance to international law that is seen as interfering in Chinese domestic affairs. And that will continue to be an ongoing conversation with China over the long haul. I don't expect that this administration or whatever administration follows it is going to resolve that question. But I do think part of it is just the US being consistent in its views and standing up for its values in all of its relations, not just with China, but with many of the other countries in the region as well.
Let me, if I could just jump in for a moment and say, this is the issue of our time. Maybe global warming is also extremely important, but experts, military experts, think that there's an extremely high probability that China will attempt to claim sovereignty over Taiwan within the next decade, and that at the moment, in terms of on war games and simulations, both actual war games and computer simulations, they will be militarily successful, notwithstanding efforts by the United States to change things. So this could lead to a significant change in the world, in the kind of global world order. We will not see idealism characterizing a major component of foreign affairs. We will see, as you point out, in the questioner's phraseology, realpolitik, and I think that's more unfortunate. That's, I think, somewhat unfortunate.
Professor, I think you're coming in and out, so I apologize if you're not completed. I don't think we can hear you anymore. Let me give you more. There you are.
Oh, good. I'm a little bit dark here. So I was ending on an unfortunately pessimistic note about what I view as America's, I believe in kind of peace through strength. I think America's military declining relative to other countries, particularly China. And I think that it does not portend well for what's going to happen in the next decade globally.
I'll just respond to that very briefly. I mean, I do think that one of the challenges that we face is that as US's relative strength compared to other countries declines, and that just is a factual reality. When you look at global GDP, share of global GDP, US is declining and others are rising. The ability for us to shape the rules is going to be reduced. And this is, I will say, one of the big reasons it is in our interests to create global institutions now and invest in those global institutions now while we still have the capacity to do so, because creating these institutions and creating structures to enforce them, structures and institutions that are consistent with our values and our view about the proper way of running the world is in our best interest. And I think pulling out now is kind of the most disastrous thing that we can do. On the question of Taiwan, I will say that I was quite nervous, particularly in the period after Trump's defeat and Biden's inauguration. I thought the chances were not trivial, that was going to be a moment at which China might make a move on Taiwan. And the fact that they didn't makes me hopeful that they won't. I hope that's not a naive view. But I do think that the robustness of the norm against using military force, I know they don't recognize the independent sovereignty of Taiwan, but there's still a robustness against the idea of might makes right and use of force to establish new rules. Those norms still mean something, and they understand that there would be a massive cost to pay for violating those rules. And I think it's in our best interest to continue to make it clear that those are the rules that we intend to abide by, that we have other states who are with us in believing that those are the right rules for the system, and that others will join us in rejecting any effort to change reality for Taiwan using force. So that's ultimately in our best interest, I think, and that's probably one of the best cases for global governance that we can make. That global governance serves our interests, our values, and it's the way in which the United States can ensure that those values continue to be seen in the global order, even as U.S. relative economic and military strength may not be as strong, as dominant as it historically has been.
Well, on behalf of our audience, I want to thank Professors Hathaway and Macy for today's debate and discussion. Eric, may I pass the virtual microphone back to you?
Yes, thank you so much. And thank you, Professors Hathaway and Professors Macy, and thank you once again, Judge Ho, for doing this excellent debate. We'll now be breaking until 7 o'clock, so a bit over half an hour, and we'll see everyone for the Joseph Story Award ceremony and for our keynote address, which is by Mike Lee this year. Thanks, everyone.